días. Buenos días a todos y a todas.
Good morning to all of you.
For the screen for translation. Bueno, como miembro de la Junta Directiva de Plena Inclusión,
as a member of the Steering Committee of Full Inclusion, I want to give you a warm welcome to all of you who are here and joining us. I'm Rafa Company. I'm in Mallorca. I'm the chair of Food Inclusion, secretary of the Amadí Besmen de Palma Foundation. I'm retired already, also a father for a young man of 33-year-old man with an intellectual disability with severe communication problems. Here, we are glad to have you all that encourage training and trying to improve the life quality of the disabled. So I want to convey my appreciation for your work, and I want to thank you for being part of this seminar and to help us make justice more inclusive. I also want to give a warm welcome and thank the attendance of the moderator and the panelists that from the legal area are here with us. Ana Begoña, and together with the rest of the AFASAC members, have a very commendable goal for all the disabled to have the opportunity to be able to communicate, to read and write, and that will introduce an alternative communication guide to make available to all the legal operators and the legal procedures. Amaya, Vice President of Forensic, who will give us a psychological expert assessment in the support procedures, and also Irene and Natalia from Full Inclusion, moderated by Carmen de Quitas, will talk about the notarial documents, and also Rafael de Assis will give us a case law document on the legal capacity. As I was saying before, I give you my most warm welcome from the Steering Committee of Full Inclusion to this seminar, and I firmly believe in the collective responsibility to create a more responsible and inclusive society. I think it's essential for those here, administration, families, entities, and professionals in a framework of trust to be committed to have a more inclusive society. So welcome, and the seminar has already started. Thank you very much.
Comenzamos con la primera mesa.
Now let's start with the first table. And so Marta Martinez, the floor is yours. Thank you for counting on us to moderate this panel and to present this guide. I'm Marta Martinez, a psychologist and a facilitator for the access to justice by the intellectually disabled. I want to thank you for having us here to listen to the three people I would introduce. They are co-founders of ALFASAC, a non-profit organization whose main aim is to encourage the right to communication for the people with complex communication needs. So I want to thank you for exploring this. It's so important, the literacy of these people. We have a very complete guideline for augmentative and alternative communication, the legal framework. I want to present them as they speak. So as I have them on paper, the first person who will talk is Ruth Candela Ramirez, who's a medical doctor, and also a psychologist. She was a psychiatrist and a psychiatrist in the health care system, and also was in Rioja and in the Universidad Oberta de Catalunya. So she's a teacher and a specialist in alternative and augmentative communication in the University of Castilla-La Mancha. Then we have Begoña Llorens Marcian, psychologist and specialist in augmentative communication for a long time already. She has experience in special education, also an advisor in special communication. She advises families and different entities. Also, she's member of the government board of augmentative communication company representing Spain, or association. So also Ana Medina Reguera, she's a language teacher and teacher of translation, and also she has the line for translation for the access of information with easy reading. Also, she has a master's for cultural accessibility, and also is a specialist in augmentative communication in the University of Castilla-La Mancha. So I'm going to give the floor to Ruth.
Vale, muchas gracias, Marta.
Thank you, Marta, for your introduction.
Bueno, ante todo, gracias, Marta, por la presentación.
So thank you, Marta, first of all, for your presentation. I want to thank the space given to us by Full Inclusion, where we can share with all of us, all of you, the work we've been doing the last year, which ended in this guidelines to try and access and help access to communication of everyone. We've been some time trying for everyone, regardless of the condition, to have the opportunity to communicate in an efficient, effective way. That's why we carried out a series of campaigns to encourage this communication rights, and we wanted to tell you about them and to put them on top of the table. In these campaigns, we designed some materials as the ones you can see in the slide, and we encourage you to watch the video on the right hand side. We don't have the time to play it now, but it's the users that are telling us about their experiences and what they believe to be the roadmap that we may follow to facilitate access to the communication of all of us. So we have also made this poster to show the translation of 15 rights. It's important for you to know that these are not rights that come from the legal sphere, but they come from a legal compact for communication by the National Committee for the Communication Needs, both for people with severe communication disabilities. That comes from ASHA. These so-called rights were written in 1992, but they were updated in 2016, and the motives, their argument is something we believe to be important to emphasize, and it's the right of all the people to emphasize through communication in their conditions of their existence. That's why we believe it's important to start from the definition of communication. I don't know, maybe you skipped a slide? Yes. We would like to start with the definition of communication by the committee. So for them, communication is any act by which one person gives or receives from another person information about that person's needs, desires, perceptions, knowledge, or affective states. So this paragraph may seem simple, but includes many different nuances, because it takes the communication as any kind of information conveyed between two people in any way, meaning that communication may take place in many different ways. It may be with an intention or not. We may wanted to communicate, or in an unconscious way, with no real intent, but we are actually conveying a lot of information. Also, we can communicate by using signs, talking in different ways. No, we can communicate without symbols, through our faces, behaviors, non-verbal communication. But for most of the people, the communication is simple, right? You just talk. No, you never think about someone who may not be satisfied by the way they communicate, but some people don't have this facility. because they have a speech impediment, they cannot use it in a normal way. You can see Betty is a young adult. I've been, well, caring of for many years. She has this eye reader where she can access a communicator. She lost speech for a degenerative disease from 9 years old, and maybe some of the listeners don't familiarize with this kind of technology. So let me show you, explain. People like Betty with permanent restrictions, well, they cannot communicate. All their communication needs are hindered, so they need some support in their communication. So for this group, we call them people with complex communication needs. An important part of the support is the alternative augmentative communication, which is defined a set of tools and strategies that individuals to solve everyday communicative challenges. And here we include everything you can see, speeches, share, glance, text, gestures, facial expressions, of course, pictures, also the speech generating devices. You can see that the ISAAC mentions tools that may be devices with speech generating devices, visual support, anything, maybe the tools, but we need strategies. And also that the people around them must know the methodology to implement these tools. Next slide. Another definition. The previous one, we'd like to mention is the definition made by STEAPAD, which is this is an institution, a Spanish institution, belongs to us and talks about a person with a speech impediment, how they interact or express themselves by counting on the necessary supports according to their need, the use of which is shared with the speakers and which enables them to exercise rights. We like this definition to complement the one from Isaac because they mention the environment to be shared by the speakers. This can only be understood as an interaction with other people. People have to acknowledge this as the means to communicate with others, and also it mentions the exercise of rights. Also, we can mention two types of augmentative communication. On the one hand, augmentative when the environment enhances the communication, and alternative when it's replaced in a full way. Also, on screen, you can see, for example, have a famous activist has autism talking with an alternative communication system through the screen by using letters and numbers. Here, after decades of literature, we can see that this works in the skills for functional speech skills and the understanding skills too. Many people like I, though, can benefit from the CAA or AAC, sorry. There are some types that come from a congenital condition or acquired conditions sometimes. In fact, the studies talk about a progressive increase in the number of people with CCN because increased incidence of different diagnoses and conditions, and also because of the increase in survival and life expectancy. In fact, they even mentioned that even 97 million people in the world could benefit from the augmentative alternative communication, the AAC. In Spain, on the last survey on disability and dependency on the Statistics Institute, they mentioned that we may have around 1 million people that need support for the effective communication every day. Before I give the floor to Begoña, we have a video, but we cannot hear what is said. So here we intend to show you some users sharing information with us. This is a clip of the original video. Here, Alejandra, an adult, she says that she has to have the right to communicate. And Juan Fran is also telling us that we have to learn how to listen. They have the right to communicate, but we have to learn to listen too. Thank you, Ruth, and thank you for sharing this work you've done. And the users of AAC, they have their own condition of the absence of speech or difficulty in communication. They have some barriers that we can say they are from the participation model. We can call them access barriers and internal barriers too. Some people may present difficulties in in the sensorial system, and also we have on the motor system, and also we have also situations where the environment somehow places upon them just because the society is just not ready to take care of this AAC people, and also maybe thinking that someone may just not be able to do this, or they are less intelligent because they not speak. This is part of the opportunity barriers or external barriers that have to be emphasized and have to be overcome. Also, Ruth mentioned she focused on the speakers, and the reality, if we review the interactions, generally speaking, the speakers, when we talk, when we address people with complex communication needs or who need this AAC systems, we tend to dominate the conversation, to talk more than them or communicate more than them. Also, we make interventions or interactions that are, very dominant. For example, we tend to ask too many questions or waiting for an answer of just yes or no. And we ask too many questions with not much space for the person to take the initiative or to be able to communicate what they want or what they feel convenient, and we don't give much opportunity for the social participation. But our figure as speakers, many times, most of the people were not used to that. So we need a series of guidelines and recommendations to be able to know how to interact with people with complex communication needs. So for a start, it's good to raise awareness of this. The people who develop language through this assisted communication, they depend on this conscious efforts of the people, the professionals, families, therapists, friends, because this kind of tools and strategies must be taught. So it's not something you just learn in a natural way. The reality is that it's very important to pay attention on the different ways of communication. No, we all communicate in different ways, and the people with complex communication needs usually use non-verbal expressions to communicate, even when they present motor challenges, for example, a person at a time, for example, where they can, with ALS, when they can only move their eyes, just with their gaze, they are already giving out some kind of nuances to the interaction, and in all, in different degrees, but everyone, even with this kind of challenges, may present some non-verbal communication form we must pay attention to, and we must enhance and validate would be is the right word. So some people, for example, to say yes or no, they don't do this in a conventional way. Maybe they do so with, for example, they may say yes by looking upwards, or no, looking downwards, or I don't know, making some kind of face. Also, we must pay attention to different ways of expression. Also, there are studies, international studies. We need more research in our countries, but there are international studies where they have stories of experiences and users in in different situations, and there's a series of negative experience they can mention. For example, they feel ignored. They talk about them as if they were not there, as they talk to the person that are with them as if that person should make the other person's choices, when it's the user himself or herself who obviously should make their own choices. Also, they underestimate their capacities or skills to make a decision or to communicate, even in an alternative way. And broadly speaking, they feel that the people around them, don't think they can make their own choices.
Other negative experiences that they sometimes report is that they're not allowed enough time or the opportunity to communicate what they want. We must bear in mind that people with complex communication needs oftentimes have a slower pace in terms of reacting, in terms of answering to questions, or in terms of responding to something that is happening in their environment. And we must be aware of the fact that time is a good, an asset that must be taken care of, must be observed, and we must allow for these spaces so that they can express anything they may need. Also, they emphasize that others are often not acquainted with this communication mode, like, for instance, nonverbal ways of communicating, going beyond, of course, communication devices, even if they are high-end type of devices. And oftentimes they just stick to yes or no questions. And we must insist on something that is very important, which is that we must always offer an alternative. Yes, no, or do you want to say something else? It's as simple as that. We also have some testimonies in our country, and we are becomingly aware of more and more testimonies. We know the work that Aspase Confederation is doing, and also what they're doing is to vindicate for the rights of users, so that they can use their own voice, so that they can make use of their own communication devices and make their own choices. So we indeed invite you to get acquainted with these testimonies. And now I'll give the floor to my colleague Ana Medina, who is going to present the guide as such. Thank you. Apologies, I was on mute. Hello, good morning, everyone, and thank you very much for joining us today. Very briefly, I'd like to take you through a journey, through some of the pages of this text. This text intends to become a basic tool, focusing on what augmentative communication, alternative communication is, and what are the different options and the different systems available for people with complex communication needs. As you've seen, we use this term to unite her to encompass the different diagnoses that pertain to people that have severe communication disorders or difficulties. And here you have the agenda or the index. Here you can see how they can communicate and how they can have the legal stakeholders who are not frequently communicating with this individual. So it's very important for these operators to have this as references. They're very diverse stakeholders too. So the goal here would be to have efficient communication with these individuals so that they are not helpless from the legal perspectives. They need to enjoy legal support in equal condition. For drafting this guide, we've had as reference scientific research that has been previously conducted, most frequently in other countries where they have a bigger track record on these issues and a series of consolidated references in terms of legal intermediation. Here we are highlighting one of the sources, which is the PhD work by White. A thesis submitted in partial fulfillment of this degree, in which they talk about accommodating persons with severe communication disabilities to core development of an appraisal of guidelines. So here we have this work that has been performed over many years, as well as, for instance, the work conducted by Penny Cooper in the United Kingdom also. And here we have other similar guidelines, like the ones that we have put together. Some of them are more specific and go into a deeper level. So we are not going to share all the details here, but we encourage you to check this at your own leisure. For instance, we have some references from Canada. Here we have some guidelines on intermediation services, communication intermediaries and justice services. This is indeed, as I said, from Canada. This website is shared here so that you can access their videos, which are very interesting, in which you will be able to see intermediaries acting in several points of different judiciary processes. Here you have some screenshots of guidelines. These guidelines are from the United Kingdom. And here we don't just have guidelines, we also have several tools, supporting tools. Some of these have been translated by us so that they could be made available in Spanish, and this is included here. Now, to the left, if you see the image, it says using communication aids. Well, something that we thought interesting is that in scientific work and in similar guidelines, they underscore the importance of tools and also using cards with phrases, cards with different parts of the body and different tools that can be used in several points of different processes. And also we have fidget objects here, which are anti-stress objects, balls and other types of objects and tools, because actually here they're focusing on the fact that we can help these individuals manage their time, the anxiety, the stress that they may be going through at that time. Here we have another website with another set of guidelines. This is for the United Kingdom, in particular England and Wales. It's made up by a toolkit, a specific toolkit to help with communication in the criminal justice system, which has been inspiration for our guidelines for our work too. Another aspect included in these guidelines, and we're always thinking about those who are not very familiar with this, well, here we have some basic instructions to understand what these augmentative communication systems are, because, for instance, this can encompass paper, electronic devices, artificial and synthetic voices, and as part of this, you can find contexts of different natures, pictures and all sorts of references, pictograms, and the idea would be here to use simple language so that we can get an overall flavor of how these people interact and express themselves in terms of communication too. Something that our colleague mentioned is that it's been scientifically tested that we hold conversations in a very specific way with these people, and we normally fall into the trap of not allowing them sufficient time. Something that we think also important is to summarize the visual aid that we can use in the semantic field of law. We've seen that indeed there is a great variety of resources here. For instance, photographs or pictograms about the legal settings. So we thought it would be interesting to tackle this and therefore to share some of these resources, not just from the pictographic standpoint, but also to the right, you can see that there's some cards or so boards using full sentences, words, alphabets, and in the guide, there's also resources that can be downloaded if you deem that suitable for you. In the chapter in which we try to describe how to be a good speaker or a good touch point, well, most studies agree on the fact that there's three main phases in which people may require help. Even though in augmentative and alternative communication, we talk about people finding a way to express themselves, and that these means of expressions, which are as multimodal as we just see, so they must be accepted by the listener, by the third party, instead of them being ignored or not given enough importance. But in spite of all this, there is a discrepancy between acceptance and understanding. So we provide some notions about what to do there. And here, once again, we have those cards that we alluded to before. These were originally in other languages, in English and German, but what we've done is to create a Spanish version for them. And here, for instance, we have this one, which is extracted from one of the toolboxes shared in gateway.org, and this is about stress management too. And then finally, towards the end of the guidelines, we have included some practical cases, fictional cases that we may be faced with. And here we actually wanted to explain one of those cases involving a fictional individual, but it could very well be real. And this includes the different concepts that should be considered to understand the person's profile, a person who has complex communication needs, as to be able to help them. And moving on, as we mentioned before, we have used the guidelines to also include a series of boards, keyboards, amongst other tools that can be downloaded. And finally, we have also done some vocabulary work based on Law 2008/01, 2021, so as to make available these texts. And based on this reference, we've tried to get the word and the vocabulary that is most frequently repeated, and that could very well be useful to go about these processes. And that's it. That would be all from us. Maybe, Bego, we could just show our last thank you slide, in which we want to show our gratitude for your kind attention and to say also that you're very much at your disposal. Thank you very much for the presentation and for the guide. I think it's super useful, and everything that you mentioned about pictograms that relate to legal services. That's very useful because we already we know that it's very difficult to find adaptations. If anyone wants to ask a question, you can go ahead and take the floor, or maybe send your comments or questions using the chat.
Mira, nos lo están poniendo en inglés también.
And they are also translating the request to see if anyone wants to ask a question.
Perdonad una pregunta ya. Habéis estado trabajando en coordinación a distancia, ¿no? Entiendo, porque sois cada una de...
One question from me, because I think that you have been working remotely because you're located in different places, so that's another difficulty.
A ver, han puesto que si está accesible online.
They're asking us whether the guide is already available online. Well, I don't know if Anna is an English speaker. She might be, because she posted the question in English. Actually, the guidelines are offered, have been posted a bit higher up in the chat. Maybe you should tell about this. You should be the ones responding, right?
Mira, justo aquí os han colgado otra vez la guía tanto en inglés como en castellano.
There you have the guideline. The speaker saying it's in English and Spanish.
Y luego Arturo os pregunta si es posible que le facilitéis los enlaces de las
And
diapositivas.
Arturo is saying whether you can share the slides. He's asking whether you could share the slides. And indeed, because the seminar is going to be recorded, we have included the URL, and in the bibliography of the guidelines, you can actually find the different references. But you can also drop us an email, hola at, well, actually, Ruth or Begoña, could you please share our email, because we will remain available through our website, hola@alfasac.com. If you want to reach out regarding the bibliography or the different links that we have shared, go ahead and write an email to us. Thank you very much. The email has already been posted on the chat, and the question is in order, right? Would it be necessary to continue to the research on this topic? Well, we have just begun doing this. We're just starting. We need to continue to identify resources and do work on this. Yes, and regarding research. It's indeed necessary to do more research in the field of alternative and augmentative communication, because communication cannot be set apart from culture. And what is indeed happening is that we are importing many elements that are not inherent to our culture, because most research is performed abroad, and that is indeed very important, even more so in this field. It is very important, very relevant, and indeed there's very little Spanish literature, also from our country in particular. And as a speech therapist, I'd like to add that still in university degrees, fortunately, they have included a subject on augmentative communication. So many speech therapists that have graduated haven't had access to this subject. I mean, it's a very broad discipline, especially we factor in the technological side of it, and that calls for greater unspecialized training. They are asking us from Kenya. They're saying that they're working with intermediaries and supporting people with communication disabilities in the justice system. And they're saying that the challenge is that the Evidence Act does not allow for use of alternative and augmentative modes of communication, including using pictograms. And the question is, how has the government enabled these adaptations in the justice system? I imagine they want to hear our example so that they can go about it in Kenya too. Maybe I could try and answer this question. During the legal reform that they did to adapt the law to the Convention of Peoples with Disabilities, we did some advocacy so that we could include a reform in the civil law to adapt procedures, legal procedures, in civil procedures in principle rather, and in any phase of the proceeding, and also in preliminary phases. But the thing is that the civil law in Spain is also subject to other procedural laws, and this article is applicable to the criminal, administrative orders, and it allows for the implementation of procedural adjustments that, amongst other things, allow for the use of augmentative and alternative communication systems. And this article recognizes the right of people with disabilities to understand and be understood irrespective of the way in which they communicate. Thank you very much, Ines.
Bueno, creo que nos están diciendo de una manera muy educada que lo
I think very politely they are sharing with us that we did stick to the time that was allowed for this section. So we'd like to thank you for this time, and even more so for the guidelines. Thank you very much. Good morning or good afternoon, everyone. I'm Torcato Cuciver. I'm the coordinator of the network of legal experts for the Plena Inclusión network, and I wanted to introduce the next participant of our seminar, who is Maya Nagore Casas. It is a great honor for me to be able to introduce her, because the presentation that she's going to be sharing, the guidance for assessing and the support for people with disabilities, this is a great contribution. It's a substantial contribution. And those of us who work with this type of systems in which support is provided for people with disabilities, until there was a reform in the law 8/2021, we had the issue that it was a forensic doctor that had to assess the disabilities, and I don't want to go into criticism, but we know that they need to know a bit of everything to conduct their assessments. And well, sometimes this gave rise to very good reports. But on the flip side, there were also some very superficial reports. So assessing disability in the different processes for providing support, etc. Then sometimes this was conducted by specialists that were not very much acquainted with the subject matter. And there is something new here, because when we talk about this, we are also talking about voluntary provision of support. And indeed, the judges need to assess a new concept, which is that of support. We have managed to introduce to the law a concept that in the past that didn't have legal entity as such. If you go to the library of a civil law section in any library, you wouldn't find concepts about or the definition of concept from the legal perspective, rather only from the social perspective. So now judges need to actually determine which is the support required by the individual in order to dictate, to come up with a ruling that actually matches what's in the relevant articles of the Civil Code. And from this perspective, therefore, the guidelines that are about to be presented, the guideline put together by Amaya Nagore, amongst others, Luis Vicente, Pilar de Luis, Laura González, Susana Esteban, and others. Well, this is actually a wonderful instrument for professionals that need to perform this type of activities. And in the professional field, and even notary publics, this is an instrument that we need to welcome with thanks, because indeed this is something that needs to be considered in the legal resolutions, to what extent the person will need that support, and therefore to consider the resolution based on the specific person's profile, so that in that specific time they know what is needed by an individual. I don't want to elaborate much more on this because it's time for Amaya to tell us about the details included in these guides that I think will be very positive for all of us. Thank you very much for the presentation and for the invitation. I'd like to specify that as you see on my Zoom profile, I'm also described as being part of this association. I will be taking the floor on behalf of the Forensic Administration of the Forensic Department of the Justice Administration, the FEC. So without further ado, I am going to start sharing my slides, and I am going to try and share my screen now. We have prepared this, and you've been kind enough to translate this because that was beyond my my skills, and this presentation is indeed being delivered in both languages. So let me switch screens for a second.
Vale. Bueno, la guía, más que
This guide,
surgir de nuestra propia iniciativa,
it doesn't come from our own initiative,
fue impulsada, fue
but it was more
que incentivada en gran medida,
encouraged to a great extent by the group of professionals that are part of defend the people with intellectual disabilities and there are some colleagues and the people that are close to the Federation of the Full Inclusion. So this lack we can see in the training itinerary of the forensic psychology from that point onwards. Well, the trajectory is before the reform of the Ordinary Act 8/2021, we received well, different voices from this subject. So when the law was passed and the colleagues mentioned by Torquato and other colleagues that are not mentioned in the guide, well, we started working on it. So the result, this is a flyer of a previous course we held in June last summer, where we presented our guide in a specialized course where Plena inclusión is a company with a mention, and we work especially on the forensic side because our association presents a group of professionals that are working as psychologists for the justice administration, both in non-transferred territories for the Ministry of Justice, for different councils for each autonomous community, with that transfer of competences in terms of justice. So this is one of the things we're worried about. As others, for example, linked to this subject, everything that has to do with the testimonial, the assessment of testimonials. And this is linked with this because many times we find people with disabilities that have been witnesses and victims of, well, a certain, well, victimizations, acts, abuse, sexual abuse, etc. This was one of the examples. So the idea was to associate the guide to some training actions so that it was linked to a trajectory. This is not obsolete, but it's a document that is very much alive and constantly changing. And that has to be part of training actions and improvement actions. We can download this in the forensic, in this web page, so you can easily find it. It's a free access document, and I'll be talking about its characteristics. I want to mention that even if it's encouraged by the lack we have, although what we're trying, to improve in the most competitive assessment for the people with disabilities in the sphere of justice. It was a practical document. So it's a forensic practice document for our use, for the group of the forensic psychology, but we are thankful that it has an impact on other groups of professionals, both legal experts and other technicians that work in the justice sphere and other groups from the third sector. It's, of course, a group of recommendations for the right design of the assessment expert psychological process. So this is founded on evidence, as all our assessments should be, to improve the quality of our legal advising, because we advise courts, attorneys, judges to support the best exercise of the law possible, but we are, we are help them in making their decisions. And it was a document and other guides that we have launched at the same time, that it tend to bring together different criteria for the actions of experts. For example, we act in a certain community or geography. This has to be carried out in a standardized way. It's not approved as a psychometric tool, but there's some kind of consensus about how we do it. So the authors mentioned by Torquato in his presentations are there, and we want to emphasize the job of the reviewers. So we had the chance, or we had the opportunity of having of it being reviewed by many experts, as you can see here. We have more reviewers than authors, actually, because the group of the people with disabilities is so broad and touches upon so many different subject matters that we needed many experts. And well, we could have gone on and on with different extending paragraphs and aspects, but it has to be a practical and a document we can digest. When it becomes a manual, it no longer makes sense. It would be a different kind of document. So we have colleagues from the disability courts in Madrid, so technical teams from the courts specialized in Madrid. So we have an attorney, the state attorney for the disability room, also the legal advisory for Plena inclusión, the INICO team for the integration in the community team. It was an honor to have them because they have the largest prestige we can count on in the intellectual and development disability world. Also, the president of the Psychologists Society of Spain. Also, in academia, psychiatry, to touch upon the different subject matters from the different groups this guide is addressed to. We had, all the literature included as broad as we could, always take into account that we needed a practical document, so we couldn't get much into detail. No, and in reviewing areas that went beyond the goal of our document. Carried out also different meetings for consensus for the work group to move forward in the different paragraphs of the work group. And we have the expert review, external expert review, very important one, that contributed many improvements and suggestions for the final document. We know that Article 12 of the Convention of the People with Disabilities, which is the main reason behind this kind of document, we can see a change, an important change of paradigm, or a change in the way we look at this, and this was urgent and necessary for the people with disabilities. About the sources of inspiration, so diversity, vulnerability, equality in front of the justice and the access to justice. I think it's an article we are all familiar with, so I'm going to overlook it. And also we have the Amendment 821 with an important change, a radical cross-section and a complex change to the entire legal system. So in a way that we cannot understand for these processes to be similar to the previous ones, just by changing some words. But what we need to implement and understand by all the ages of change is that the gaze is different, the way we look at it is different, and the processes should arise from a different point of view, from the will, respect of the will and the preferences of the disabled to decide on matters that are essential or important, and of which that person is a protagonist, and not making other people protagonists or third parties protagonists. We can see some of the quotes that we included in the guide that can, that show how the core of this directives for this inspirational principle. So the will to, respecting the will for the decision-making processes. So for what kind of legal procedures do we want to improve our expert assessment practice. Well, for the support needs, to assess the support needs, which was the final step in this kind of assessment. But we'll have a trajectory of expert assessment by professionals that have some kind of awareness in this subject matter. It doesn't mean that we are specialized and we have an official specialization or approved one, but our professional obligation is to be more and more specialized every day, as happens with the violence against children, against women. So many different things. We have to keep on with an ongoing training. So these reports must come from the healthcare and social area. So in the healthcare, we include the psychologists. And also the law says that we should have roundtables with different professionals. This entails having a close relationship with the technicians that assess councils and lawyers. And it's something we should work on. As you can see in the presentation, we have different types of documents, no? We incorporated instruments or instrument proposals, psychometric for different populations. Also, we incorporated documents from scholars or more in line with mental diseases. Also, we have to carry out the full assessment of the adaptive behavior of how a person is able to participate to be involved in a community. And for different pathologies that will not always be a pathology, but many times we believe, that are actually these illnesses that are, for example, neurodegenerative disease or of a different kind. So it's like a tailor-made suit for a special legal situation, such as making a health decision that is important for the person with a disability to be subject to a treatment or not, so clinical essay, the financial aspect, or the ability to driving motor vehicles. This will not always be a legal part, but it will be part of the administrative side. And also we have the testamentary capacity, also the ability to carry out contracts or to sign contracts. So we don't have tools, so specific tools or an approved methodology, but we have to build it for this, to make the best legal decision possible. So the psychological experts for disabilities and for the supports will be diverse. Our work should be applied and requested to decide the best, kind of curatorship. This should be legal or representative to have the adequacy of a visit system for the person with a visit or schedule, to have a monitoring of meeting those legally decided measures. Also, to have the degree of vulnerability, if the person has all the undue degree of influence for that person, how influential they can be for external agents. So the conflicts of interest for the different options of curatorship or supervision, for example, advising them for the possibility or the improvement or the presence of a legal defender. The person with a disability entails a risk, for example, an aggressive behavior to third parties and the evolution of the abilities of the person with a disability, because the disability is not something uniform, stable, but it says something that changes all the time. So the program and individualized supports will be subject of the appropriate adjustments on the legal sphere. And for the situations, for the tailor-made suits for new circumstances that may present themselves throughout the life of a disabled person. We emphasized before for that the forensic office shouldn't be the only one that is called upon for this kind of reports. This report of the United Nations makes clear that one of their directives is that, as of today, not a single disabled person should have less access or less legal guarantee than another person. So we should amend or eliminate those practices or laws that authorize or enable the professionals to be preferred experts or the only ones to be taken into account when deciding on the ability of a person to make decisions or any other purpose or to testify. So the diagnosis is not the only important thing. Our guide is for 3 broad groups, and from which we can see different branches coming out to improve this standardization of practices and standardization of criteria for the psychological expert assessment. So we have the people with the disabled, intellectually disabled, also people with brain damage that is acquired or neurodegenerative people. Some criteria, basic principles of the expert's function. I'm going to go quickly here, but we mustn't forget that our assessment here should be addressed to drawing up the support measures to enable the full development of the personality and that full access to justice for the autonomous decision-making in conditions of equality. So the profession of the forensic psychology will need the attendance and support for the direct exploration of the person with a disability, will need a facilitator to improve the access or to guarantee that cognitive, linguistic, to access to the environment. In this case, the legal environment. So the facilitator also will be part of the police, department, for example, when filing a lawsuit. We should take into account that people with disabilities here present an important social desirability. Well, they try to hide their disabilities. A dissimulative attitude is what we call. And this is something we mustn't forget, because the methodology should contemplate methods of detection for the possible distortion of the symptoms. These are assessments that are multidimensional, a multi-source. We should always have more than one source of information and preferably as truthful as possible, because our reports are based on data convergence. So we're going to mention well, the family members, people that are close to the disabled, therapists, or the providers of supports that have a full perspective of the person with a disability. We have cross-sectional assessments. So, many times we mustn't forget that we don't have a connection with the people under assessment, but we know them in a very particular context, which is a legal procedure at a specific time of their lives. The context is an essential part of getting to know the person in front of us. And well, we'll talk about the context later, because many times we don't take into account all the variables of the context. So that's why the information of third parties and objective sources is very important. And of course, documental sources and the medical report, etc. Even if we don't make reports as such, we don't gather a person's report and summarize as like a documentarist, as other kind of informant could do. So we have to know the background, but we take them into account to understand the social situation of the person under assessment. So focusing on drawing up an individualized profile of supports, we will pivot in three main areas. So exploring self-determined behavior. This is the ability to decide. Another thing is made up of all the psychological processes, functions, mental activities that, well, are at the foundation and will determine their behavior. And a large leg here is on the adaptive behavior and how that person, well, navigates the context with the supports they may have or not. So, in other words, the five main blocks will see, so the self-determined behavior, the ability to interact, pathological state, appropriate, the dimensional assessment of the person in certain cases, the social cognition variable, the adaptive behavior, and drawing up an individualized profile for support. As the international classification of the health capacities from the World WHO for the assessment model that we will carry out, the situation of the person changes every time or may change depending on their personal elements, the environmental elements that enable facilitators and sometimes barriers, and of course the opportunities they may have in their environment. But the self-determined behavior may be encouraged and developed, activating the support and strategies of intervention that are appropriate for this person. Here we may include, well, we will see what I mentioned, because in the experts context, it's necessary to use standardized tools adapted when they are drawn up in other cultural contexts and countries and with other samples, adapted to our population. So we have underlined the efforts made by the investigation that are tools standardized for the self-determination. So here, the population with a disability, we have the Autodis scale, but we'll mention others that have to do with the quality of life and other collaborators. About the psychopathology, we have the use of the self-reports. I'm not going to specifically say how they work, but because these are user recommendations. About the intellectual, functioning, we are lucky enough to have multiple tools in our country, classic tools that have been implemented and updated little by little, and that measures with a very high degree of reliability the intellectual performance variable. We prefer to focus on DSM-5 for assessing well the functioning personality scale, so that they express themselves in a functional way, both within the self address and also in how they relate to each other, how they interact with each other. So with things such as empathy or in their intimacy environment. So this is important for some cases where we talk about complex interpersonal behaviors. The, of course, executive functions, from the neuroscience sphere entail or make the foundation of to say how that person is able to carry out decisions in a more simple way, a day-to-day decision or a complex decision too. For example, a legal decision that entails important changes in their lives. We incorporated in the guide the things that have to be with social neurocognition, social cognition, with schizophrenia, and also the assessment processes that have fortunately produced standardized assessment tools. The adaptive behavior is something we should assess, and we mustn't forget that there are different gradients of layers of difficulty, whether it be from the conceptual, social, or practical standpoint. Also, we have instruments that are adapted for this, and we will use them with the advantage that many of them also include the opinion of the person that is close to the disabled. Also, I mentioned in the intellectual disability, the social desirability, the need to be accepted, to try to have for others to perceive the best image possible as can be expected.
But for instance, in neurodegeneration or acquired cerebral damage, sometimes there is a deficit of symptom consciousness that stems from an associa, which is a Greek term that reflects when you don't realize a situation that is going on. With people who have brain damage, sometimes they cannot manage to perceive some information. Sometimes they don't just have access to that information because there's a lack of reception in the brain because of issues with the motor system. So we are talking here about organs, and therefore it's very important to have the support of people around you. The relative doesn't really realize that when there's information that needs to be processed by the left side, because they've had a stroke that has had an impact on those regions. So we must offset that situation. And this in the adaptive context is something key. And this is why these tools always include information on acquaintances of those people that are most familiar with the people with disability. We've taken on the Thompson definition for this profile in order to define the psychological construct, the pattern and intensity of support needed by the individual to participate in related activities with a typical human functioning in the labor and the professional, social, and the partner contexts. But there's very many context factors that can actually hinder the expression of specific behavior. And indeed, in the various systems, sometimes there's overprotection by all agents, not just the families. Also, the judiciary system also sometimes overprotects by not giving voice to the individual, given lack of opportunity to participate, or, for instance, pitfalls in training pathways that don't allow for access to special jobs or protected jobs. The meso system, lack of support network, rigidity, employability, and segregation. And as part of the macro system, and here we have the negative position by some spheres of society, lack of social or awareness regarding the support needs that these individuals need. The final step would be coming up with the features of this plan, taking into account the will of the individuals and always respecting their needs. And fortunately, we also have intensity support scale, a support intensity scale for this type of situations. And I'll stop here, and maybe we can ask questions at this point. And I really hope that the presentation was clarifying and not too dense. You can have access to the full document, if you will, and you can address the APF to share your comments, doubts, and of course, we will be more than willing to entertain them. Thank you very much, Amaya. I'd like to begin by apologizing because I didn't do the introductions adequately. Well, actually, I didn't even introduce you. I then presented the guide directly. It's the main point here. The document deserves a spotlight here. But you very well deserved some words. And even though this was implicit in the presentation, she supported me. So Amaya Nagore is a forensic psychologist at the Medical Center for Forensic Sciences in Segovia. She's a co-author of the guide that she explained. I could elaborate on her CV. She has performed a lot of work on the subject matter, and she's been a lecturer at several masters, and I apologize for saying this after I should have. And now, well, we'd like to go on to the Q&A, and actually some people are asking us, what is social cognition and how would you assess it? It's a broad spectrum, and there is no consensus in research yet. Maybe we could stick to a more classical definition of social cognition. I'm trying to find it, actually. It's about implemented socially adapted conducts, including variables such as empathy, well, starting with the identification of your own emotions and other emotions, empathy at different levels, because as we know, there is a first and second and third order empathy, pro-social behavior, attributions that individuals do also, in the sense of what we consider to be the cause for a specific result, for a specific behavior. So it's a broad spectrum of behaviors adapted to norms, also based on the cultural and functioning systems. So it's a very interesting variable. Then we have awareness, how we are able to understand nonverbal behaviors in others or understanding their attitude. An attitude can tell us whether the person is upset, irritated, nervous, and I can adapt to that type of communication. So it's something that we implement in our relationship with ourselves and also with others. We have another question. Well, not really a question, but rather a remark. And this actually points at our reality. They're mentioning that even though the law talks about health and social spheres, in reality, in many places of Spain, and actually I can attest to it in disability courts in Spain, the reality is that this law is not complied with. These reports are not always requested as something mandatory, and this is essential for support processes and also with the law 821, which also requires a very direct assessment of individuals. So what's your perception about this? What's the association doing about this? Well, the association has published a guide and we see that it's been positively welcome. The feedback that we are getting is that this document is landed in the hands of legal experts and professionals like the ones that are meeting here in this forum, and that it's very much welcomed by them. We are very satisfied by this, but this is just a drop in the ocean. And of course, many other efforts need to be steered toward this because in courts they have lack of resources. But on top of that, you need to add the fact that there's no specialized training provided, and that's something that we're trying to work on from our association. Our public administration managers are not frequently the ones to promote actions about this, but rather the professionals that are trying to push for this bottom up instead of it being from the top down. And indeed, the experience is that this is scarce and it's terribly insufficient. We must emphasize that psychology, like many other professions in the healthcare system, this is something that needs to be under the spotlight because which of the variant, for instance, self-determined behavior, can anyone think that this is something that is completely different to executive functions, to decision-making, memory, planning, behavioral oversight? I mean, psychologists have in our hands a broad range of tools and trainings to assess all these functions. So it's not just enough to draw from impressions. You can't just say, I think like they're getting the context right or the contents right. You need to do a detailed assessment of all these variables. And I think that these requests these reports are really not being performed in this way right now, and we're very much concerned about this. This is one of the limitations in the law. As I pointed out in the beginning, right now laws impose on judges that they assess the level of support, and sometimes judges have reported that they feel frustrated because how can they determine what the needed support will be. And in a way, it's also established by the law that they could do this through interviews. And It's true that they cannot just evaluate this with their own eyes just like that. If they don't draw from technical reports, then the assessment will be lacking. And when psychosocial systems need to respond to the courts because they're also overburdened, just to correct something, the correct terminology is technical teams formed by social workers and psychologists. As you know, we are very much overwhelmed and saturated, but if they don't make the requests, we won't be able to respond them. If they request to us to share expert reports, then we will be able to say, listen, I cannot respond to all these requests that amount to however many in the year 2023 because I don't have resources. And then ask for those resources on that basis too. So I wanted to wrap up by making a calling. If legal experts recognize our validity, then they must request this work from us. Maybe we will have to respond, I am sorry, and I cannot respond to this because I don't have the capacity right now, but we are not currently receiving this request. From the practical perspective, I'd like to say that from the Institute of Legal Medicine, and according to the competence established by the law and in the regions, we have the different professionals at the disposal, but is this something that is led directly to psychologists, or are forensic teams working on this? It's important to consider what needs to be subject to this legal expert position. Whatever party needs to specify what they need to know, what the object and the question is, because if they do that, it will be better channeled. I couldn't respond to this adequately because, as I said before, we're not really receiving the requests. So the feeling is that they continue to request this from doctors and not so often from social workers too. So the better it's formulated, saying that I need a legal expert position, a psychological expert position to decide on whatever it is that they need us to decide on, then the better this is defined, the better we will be able to channel it to the relevant professional. They're also saying that in some regions they have outsourced these services. Well, it could be, as long as that's done adequately, but I'd like to stand for the fact that public services need to offer enough guarantees to do well something which is indeed substantial. It looks like civil issues, contractual issues are better catered for than these issues. I think that family judges are very much concerned about these situations that affect individuals with disabilities. They see that they're very much limited in the way they can adapt their decisions. And indeed, the way forward would be to request reports from professionals, from healthcare professionals and care professionals who are supporting these families, but also from experts, from forensic experts too. And that includes not just forensic doctors. There's other variables that need to be included. And for now, we need to continue to work on that. Thank you very much, Amaya. We took an extra few minutes, but it was very relevant to discuss this. And we now give the floor to the next participants in the seminar. Thank you very much, Amaya, for everything. Thank you. We now give the floor to Carmen Velasco, who is the Basque Country representative of the Autismo Foundation. Good morning, everyone. Firstly, I'd like to thank you for inviting me to facilitate this panel. For Equitas, it's always an honor to participate in the fantastic work that you do and to continue to learn constantly. I hope that this is an occasion for notaries to make the best of these collaborations as we have traditionally done. I'd like to welcome Irene Yepez from Libes Foundation. Hello, Irene, how are you? And Natalia Perez from Plena, inclusión, España, Spain. The title of this panel is a presentation of the results of the project, notarial documents in easy reading. In this panel, what we want to do is to discuss the importance of this project, which has been performed by Aikitas Foundation in collaboration with Liberty, Plena Inclusión, and ONCE Foundation, in order to create documents that can be accessible for people with disabilities. And in concrete, we're going to be talking about notary documents, notarial documents. So I encourage you to share anything you deem important for us to know, which is indeed a lot. And I'll try to interrupt you very little, because I think it's very important for people who listen to us to come to understand that it's very important for this document to be put together comprehensively to make this more accessible for people with disability. I'd like to share that Aikitas is the foundation of the General Council for Notary Publics to support people with disabilities and people that are in a situation of dependence. And next year, we will be celebrating its 25-year anniversary. In Aikitas Foundation, they have representatives across the whole of the Spanish territory. I'm the delegate at the Basque Country. I'm also a vice dean at the Notary School, therefore, or the Notary VAR, and I am perhaps more acquainted with the topic at hand than other colleagues. And I think it's especially relevant that we're tackling this topic right now. And let me share briefly that we are indeed talking about 2008-21 and the law 08-21, in which they was doing the greatest reform after transition. And this reform has changed specifically 8 legal texts directly, and others have been modified indirectly. And this reforms Article 25 of notary law, which is of the 28th of May of 1862, and regulates notary actions from the standpoint of practice. Now, this is an important article because its reform has resulted in an introduction, an explicit introduction of the obligation for the notary to use all the necessary means at their reach to make accessible for people with disabilities the exercise of their legal capacity when required in a notarial context. It says to guarantee the rights for the people of disabilities. The notaries will put at their disposal the necessary means, including augmentative systems, Braille, and after that there is a full list of different access possibilities. But specifically, the project that we would like to present and explain today has been pushed in the context of the reform of this article. So we are going to focus on whatever it is that you want to share about this. And I'd like to begin by asking a question to Natalia. Natalia, having said this, how has the project been organized? Who has participated in it? Firstly, thank you very much, Carmen, for giving me the floor. The project was coordinated by Plena Inclusión and Aikitas Foundation, and it's lasted 1 year. It's been conducted across 5 regions: the Canary Islands, Castilla-La Mancha, Castilla-León, Catalonia, and Madrid. We've had people with disabilities participating in it, cognitive assessment services in Plena, inclusión, notaries, and entities part of LIVER. 5 cognitive accessibility services have participated in it, 1 for each region in which the project has been conducted, also different notaries belonging to AEGITAS, and there was a twofold approach to participation. People with disabilities interested in signing a notary document could participate, and also people with disabilities who had already signed a notary document, but who didn't fully understand the document or the scope of that document. So in total, we've had 6 people with intellectual disability participate that went to sign a notary document, and another 6 that have had the already signed document adapted to have an easy reading version at their disposal. We also had 7 support entities that are part of Level Foundation participate, and they also provided support for the people involved in the project. What was the objective of the project? It was to explore whether it was possible to make it feasible to draft easy reading documents, explanatory documents that would make it easier to understand what notary documents were about, that were especially relevant for people with disabilities, to better assess the scope of the documents. What is it that happens when you sign such a document? What are the contents? And what will be the consequences going forward? So what we wanted to do was to assess the scalability of these versions in easy reading. So in addition to the explanatory documents in easy reading, what we've done is to create versions of the documents signed by the individual. And here I'd like to clarify that the person that was given to the individual in the easy reading notarial deed was not really the notarial deed, but rather a version handed to the document by way of information. These are documents that don't have a legal value, such as does a notarial deed. Now, how have we worked? We have 5 territorial groups across 5 regions. They were made up by notary publics, the cognitive accessibility service of that region, and the support entities that supported individuals with disabilities. Now, the first thing that we did was to see which notarial deeds had more interest for people with disabilities, and we selected 5 documents to work on the different territorial groups. We always included the voluntary support measures, which is included in the law 821, and which indeed is very relevant. Now we put in contact the participants with disabilities with the notary publics in the project so that they could go to notarial offices and have a first interview and start working on a document that was especially relevant for that individual. After the first contact, then the notaries put together a document in which they explained the notary deed that was going to be created, what was the scope, and always took into account the main difficulties in understanding or the main doubts and queries that they had worked on during the first meeting. And then this was adapted to easy reading by cognitive accessibility services. As I mentioned before, in the cases in which a document had already been signed, but the person had failed to understand the content or the scope of the notarial deed, they also had an initial meeting at the notarial office where they worked on the document with the people with disabilities, and they tried to make them understand the document, and then they also created an easy reading version of the document. As a consequence, over the course of this project, we have adapted 22 notarial deeds and 24 explanatory documents have been drafted. We are going to see that we worked on voluntary support measures, and in the territory of Catalonia, we worked on the testaments, buy and sell contracts, marriage deeds, anticipated sale, donations, protected assets, general powers, and personal loans. These were documents that have been selected as those that were especially interesting for people with disabilities. Based on these documents that were signed over the course of the project, we tried to create a model to try and come up with a more standard structure that could be used in the future in notary offices. Now, even though the different notarial deeds are different and they portray the different needs of individuals, the idea would be to create a general structure so that these documents that have been signed will be anonymized to try and create specific templates that can be used in notary offices in future cases. Thank you very much, Natalia. This was a very detailed and brief explanation too. It's amazing that we are discussing this type of things because as notary publics, we know that people with disabilities traditionally didn't come to our offices, or if they came, they were always accompanied by someone and they remain on one side. And the notary publics didn't have the possibility to interact with them as we do now. So that was a big leap from not being able to relate to them from a professional level. Or if we did, it was based on our intuition or maybe our expertise, but not having your experiences. I mean, having done this work has meant a big change in practice because it reassures us and it allows us to gain greater knowledge about the people with disability and become closer to them. And this is something that we couldn't have done on our own. I was listening to you and I was thinking it may seem self-evident and simple to do this type of project, and nonetheless it has a great impact to do such a project. So knowing that in the past persons with disabilities had very little relationship with notary publics, now because we relate with them as we do with others, we can draw from this type of documents. You listed some of the most important notarial deeds. These are the most important for any individual. This is something that I'm sure was considered in doing this selection. So with this type of exercise, this type of documents, any individual would have the exercise of their legal rights quite practically guaranteed. And if we are actually resulting in this, I'm sure that there's a great detailed work behind this. I'd like to ask Irene, after having done all this work, what are the conclusions that you have drawn from this after having completed the work and after getting acquainted with this area much better? What's your position about this? I'd like to first say hello and thank you for everything that you have mentioned because it makes it easier for me to reach conclusions. Well, what can I say about this project? We've been able to extract conclusions using assessment tools that we have been sharing with the different stakeholders, validation teams, persons with disabilities, their supporters or their aides, and notary publics.
Well, broadly speaking, to try to check that the people that need to have this notary public service that have difficulty in understanding, to have a text that will provide them with necessary information, and in this way both the disabled and the supporting persons and even the persons that worked on invalidating the text have conveyed a positive result in the sense that they confirm that the text developed give enough information for the text to be understandable so that the people that are signing them for the first time can truly understand, and also for those that already had a document and maybe they didn't understand it or not in to its full extent. So this understanding well, makes easier the decision-making process, so that this is what we want for the people to make their own choices in an easy way. So, or maybe, or at least have an important involvement in the decision-making process. For example, if it's something that, well, let's say in cases of inheritance, where they share some kind of heritage with legacy with my family members. No, some people sometimes are replaced and they just listened without understanding anything. So that significant involvement in the decision-making processes has to be taken into account. It's important to mention that these documents only favor the decision-making processes or the understanding of what these things entailed, but it also, well, help us have a reference for the future. By this, I mean that sometimes the person may understand at a certain point a decision and make the decision, but in time they may forget the orientation of the scope of that decision. This is something that happens. So with this tool, not making accessible these notarial deeds, we not just help the person making the choice, so that in the future for them to understand why they made a certain choice, and that they keep that in mind. And this is important so that they are, well, they own their decisions. I think all these tools facilitate the notaries public their job, and they empower the people with disabilities so that they can well address different matters in their day-to-day. Also, I think one of the main results is that all the parties involved, this was a positive experience, and in this assessment tools we used, they mentioned that building up trust, generating a safer environment for the notaries public, so they feel, well, more confident when talking to people with disabilities. And all these elements are essential so that the person who's going to make a decision does so with guarantees. Because I think I'm not saying something new when I say that to understand and decide on something, it's important to feel confident on your choice, to have to feel listened to feel like you can actually make that decision. So when creating those safe environments between notary public and the person with a disability is important, and this may serve as an example to keep on improving this, because this is one of the results that sometimes you don't see, but it has the largest impact, not to favor the person to be able to come close or not be afraid to making that decision, because they have the supports they need, and also well, with the facilities they provided by the notaries public. Also, what you mentioned, that having these texts, both for the models and the explanatory texts, helps these people. They give them previous information on what they're going to do, so they can work on this at home or in their associations with the people that support them. And not only it facilitates their understanding, or makes it easier, but also they provide for a safe environment, enabling for, making questions to the notary public. Also, an important thing is that you, Notaries Public of Spain, you have those documents available. That is an important help, as you said, no? Each document has to be adapted to the specifics of each person. You cannot use a model one model for different people because each one has its own particularities, but it is a starting point that will give some security so that Notary Public and make their work easier. The supporting people have said that the tool has to be completed with the job of the notaries public and with other tools, communicative tools. And in line with this conclusion, I want to emphasize that this is just a base or a basis that enable. Well, this gives a good basis, but this must not be applied in all cases. It's just a reference. And also, what we are concerned about now is on how to move forward with the project, how to make for the equality of the people with disabilities to be real, no, which is what we are mentioning all the time in the seminar. That the project has proven how useful it is, but it was a pilot test with a few notaries public that, well, were very much involved and made things easier, but we have to keep on working on it and look for funding for these kind of projects, for funding facilities. So we've seen that the reading of these documents is essential for the people with disabilities to be able to use the notarial deeds as the rest, but we cannot put upon them the cost of these services. So I think that these projects is one first step in searching for a funding that must guarantee that everyone has access to these adaptations. Thank you, Irene. In line with what you're saying, all this is very interesting to convey the context of the person with a disability when they come to us, notaries public, and so that we can understand the importance of this project, since understanding the law is, well, in itself complicated, and it calls for a technical training that enables this. Also, when we have a person with a disability, not only they have their deficiencies in understanding that have to be supported, but they also have, what we all have is a lack of understanding and right. So to understand the context of these people when they come to us, notaries public is essential. And this way, I want to enhance what you say as to how having the document in advance to have, so that they can read it, understand it. This changes the context and making more accessible the notaries public, and this is completed with the notaries public assessment that has to take place, and with a specific case and making a tailor-made suit. This makes for the legal capacity to take place, because we have the trust, the personal relationship that has been created, because it's something we build, because the person with a disability understands. Sorry, I'm going to have to, sorry, okay, I'll continue, because this, we can build trust because a person with a disability understand who the notary public is. They understand the document they are facing to meet their needs. This is what builds up trust. And so building this relationship before we sign the document, this is very important, because we couldn't build it otherwise. No, we wouldn't have the possibility of doing this. So the fact that it not only is a document that is signed, but that the person enables them in the future to assess what they did. My experience with the people with disabilities confirm what you say. Many people go back home after signing well, and they don't have a problem of what they did because their assessment capacity is diverse, but the person with a disability, they have less possibility to memorize, and then they are left alone. So they can have a larger uncertainty than they previously had because they may hesitate about whether what they did they really wanted to do or not. So that future space you're mentioning, I think it's a very smart thing to take into account because of the context we are working on. The fact that the document is not a form is also very important because, well, in no case, because we're talking about people who present standards or criteria, I mean, we can forget about the tailor-made suit and insisting for this being a guide that notaries public, well, know how to approach or address people with disabilities is very important because otherwise we would be at risk for the documents of for the people with disability to be less valuable because we will spend less time on them or to have less content included. So all of this to say that all the data you mentioned are essential. And I'm surprised that everything you said is so important. So that's why I want to emphasize some aspects. And here, Irene, you believe these assessments is just us who made them, or the people with disabilities will be able to come to the notary's public? So this encourages them to come to the notary's public. Because one of the challenges as notary's public is to be able to access them, to tell them, you can come to us. We can take care of your needs. How do you see this? Yes. Having all that previous process, and this is having the text to understand everything, to have the necessary supports to understand what you're doing. No, the law firms, no, the offices is something that can be a little overwhelming. No, you get to this office, everyone is so serious. The person who welcomes you may not have the right sensitivity, or you may need certain things, the waiting times, no, to be waiting there not knowing what will happen. So these things hinder and alter the decision-making processes because these obstacles. And I'm going to emphasize one thing from the project, but it's a series of conditions that maybe we don't take into account when we carry out a service. So for these people to have the documents previously, work on them, to measure them, to know where they're headed, to be that the notaries public are close to them and that they explain to them that people like them already went through this. So to tell them, don't think that because of, I mean, of who we are people nonetheless. So it's people with people. That's our tagline. This is who we are. No, we are all people. So I had the chance to know many notaries public, especially from Equitas. And these are people that are approachable, that talk to you, that explain each document, because you have the obligation to do so for every single person the same way. So to be able to explain to these people to try and build the previous safe environment is something very helpful. In fact, we have been able to see, maybe not so much linked to this project because it's a very new, but associated to the reform, to the possibility of going to the notary's public to set up the support measures, the voluntary support measures with the reform, and the possibility for people in the foundations that went through a legal process, and they say, well, in my revision, I want to go to a notary public and to well, to do this voluntarily because I think it's something I can do. So we are conveying with all these projects and with the information, the will to approach the notaries public to do different acts. No, the legacies is something that the people with disability want to do and have wanted to for a long time. But now they see this as something that is easier because they have more facilities. And this project not just eliminated barriers in terms of flexibility, but also emotional barriers. Facing a process where important decisions are made. In many cases, the emotional barriers for the people with disabilities are even larger than the accessibility ones, because they cannot be seen, but limits them. When you are afraid, you avoid making decisions, or you just don't making and when you're in a safe environment, and you can handle the information, the decision-making process is completely different. So I think this project did encourage people to approach the notaries public, to go to them. And well, before giving you the floor, I want to say that they should encourage notaries public to approach people in general. Oh, this has to go both ways. In the foundations, we are just going to give you all the provided information, the documents, etc. But we have to make for notaries public to be involved, because they cannot depend on the will of one specific notary public for these people to be able to carry out certain acts. It has to be something that goes both ways, and I think it's a reality. Great, thank you, Irene. I value your contribution so much. I'm making my notes because this is so helpful for me. Yes, we are very much aware. We have a long way to go with our colleagues, because as you say, not everyone has the sensitivity they need, or even if they do, they don't have the know-how or the experience. In Aguitas, we have many notaries public working, thank God, and all over Spain, and we are working at schools to communicate our colleagues all the information to answer questions, and even we have training days. So I think in time, if we continue like this, being patient, more and more people will feel comfortable working with people with disabilities. And also I think that, the realism would be something wonderful, because as people come to the offices, well, we get used to dealing with them, and they find the way to be trained and find the right supports to help them. So here I am optimistic, and it should always be a joint effort. And here, Natalia, Irene mentioned some of the challenges, and so what other challenges do you see we're facing from now on, so that this is not, we don't stop here, so that we continue with our work?
Bueno, muchísimas gracias, Carmen.
Thank you very much, Carmen. As has been raised over the presentation, there's some challenges that we are currently facing to continue with this line of work.
Una reflexión muy buena sobre el tema,
Some of the challenges have already been raised by Irene, which is the issue of the cost of documents, and how to deal with this. And we have tried to see whether we could tackle the costs that are linked to easy reading, and we've touched base with notary offices, because this is part of the notarial deed. It doesn't create an additional cost, but there is a cost that has to do with adaptation, because as you both rightly pointed out, we've tried to come up with a model that can be done together with notary publics, but it's true that we must do this in a made-to-measure way. We are going to therefore have a template, but all notarial deeds will have to respond to specific particularities that will have to be adapted to the easy reading for each of those documents. So having templates, having models, having explanatory documents will be able to buffer the cost of adaptation to easy reading, but we need to work on this. And we must bear in mind that this is a cost that must be borne by the person with disability. Accessibility is a right recognized by the law, and we are all entitled to understanding the legal steps that we must take, so overburdening with a cost will be equally discriminatory. Another challenge is raising awareness amongst people with disabilities about this possibility and the tools that exist now in notary offices, and we need to provide further training for notaries on intellectual disabilities. When we asked notary publics whether they had previous experience dealing with people with disability, they say yes, but that they normally had to face the barrier of lack of support. And it's necessary that they draw from the necessary channels for the individual to be able to understand. So it's important to raise awareness about people with disability and their environment and provide training accordingly. As Irina mentioned, it's important to disseminate about these tools. It's important to share that these tools are currently available at notary offices, and it is important and it's a challenge going forward. And finally, also, as Irene mentioned, we have been able to see over the course of the project that all notarial deeds can be adapted to easy reading, even though some documents have different difficulties to be adapted and to be tackled by notary publics. One of the objectives is to continue with the work so that we can have as many documents as possible in easy reading. Those that can be subject to this because they can follow standardized structure, as we did with the models that were part of this project, then we will be able to create those documents. And this, of course, compels us to continue to find new ways and new tools that will enable us to advance in this. And now the next step that we have taken is to start formatting this document so that it can become they can be converted into something more visual and understandable. And I just wanted to point out that I'm going to share a link on the chat. You will be able to download from that link the conclusions document that actually summarizes what we have been discussing in the seminar. And there you can see the outcomes of the project. You can see the conclusions by notary publics, by people with disabilities, support entities, and accessibility services too. And in the end, there is an annex that takes you to the different adapted documents and training documents. So you can have access by clicking on the link through the website of Aegitas, the website of Plena Inclusión. You can have access to these documents and all other adapted documents. And the idea is that the more people that access this, the better. Thank you to the two of you. We take a good note of those challenges that have been very well listed, and we will continue to work on them. And hopefully when we meet again in a seminar like this next year, we will be able to share the progress that has been made and the conclusions that we've drawn for it. Maybe we need to wrap up already, but maybe we can open the floor to our audience. I am looking at the chat now. Yes, I see that there's a question that you could respond to, and I imagine it's for nerds more than anyone. Whether they request some sort of a report on capacity if they have doubts. Yeah, let me see how we perform. Let me explain how we perform our function. We need to judge the capacity of the person with a disability as we would do with any other individual, not to diagnose them, but rather to make sure that we can get to know their will, that the person is there freely, and that has the necessary advice in order to provide consent. And oftentimes we will be the ones providing that advice. So out of all those observations that we need to make and that we do simultaneously in direct communication with the individual, what we must do is to put on the table doubts that we may have as to whether the person is acting freely or not. And how will we solve those doubts? We will get to know their environment first. We need to know, we need to interview people that are identified by an individual as their supports or their aides. And we need to understand what their limitations truly are and what part of their skills are impacted. Someone may be very clairvoyant, but they have difficulties in expressing themselves. It's not the same as if that person has an intellectual disability and therefore doesn't really gauge well the consequences of what they say or do, or may be influenced not just by third parties, but also by their own deficits. So we need to use all the necessary resources to reach a safe conclusion. So we always request reports, not because we're trying to strive for a diagnosis. I insist because indeed we've left aside the pathological medical system. Rather, what we try to do is to better assess the capacity of the cognosis of the person that we have in front of us. If there are no other questions, I'd like to leave it here. Once again, thank you very much for inviting us. It's been a pleasure. It's been a pleasure to discuss this with you and to meet you, Irene and Natalia. So I'll leave you here and I give you the floor so that you can continue with the seminar. Thank you very much, Carmen. And now we'll pass it over to the next panel. In the next panel, we're going to hear Esperanza Alcaín and Rafael de Asís.
Hola, buenas tardes.
Hello, good afternoon.
Bien, pues ya para terminar
And to conclude
que hemos venido desarrollando,
this seminar,
tengo, bueno, yo soy Esperanza Alcaín, profesora.
I'd like to say that I'm Esperanza Alcaín. I'm a professor for civil law in the University of Granada, and I'm a patron of the Institute for Disability. And I'd like to introduce our next speaker, who is Rafael de Asís. He's a professor of law philosophy in Carlos III University in Madrid. He has a lengthy resume from the academic and researcher standpoints. He has many publications, he's led many PhD theses, etc. Out of his CV, I'd like to underline that he is responsible for the network El Tiempo de los Derechos, made up by different research groups in which they perform studies on law, and they also organize high-level meetings, etc. One of the lines of research of Rafael de Asís is that of the rights for people of disabilities. He very well knows the theory. He's a law philosopher, but also he's very much acquainted with the practice. Today, he's going to be presenting the report that has been put together by the Observatory of Jurisprudence and Support Systems for the Exercise of Legal Capacity. This observatory was created in March 2022 by virtue of an agreement that was promoted by Plena Inclusión Spain, including LIBER and the Institute for Human Rights, Gregorio Pérez Barbas at University Carlos III of Madrid. And from the observatory, the strive to achieve more inclusive justice, which is a topic at hand in this webinar. And amongst other goals, they try to identify good and bad practices in the application of law 821. The observatory has prepared a very interesting report that showcases good and bad data, and today this is going to be presented by Rafael de Asís. Thank you very much, Rafa, whenever you win. Thank you very much, Esperanza, for your introduction. Thank you very much, Plena Inclusión, for inviting me to partake in these sessions. And I apologize because I haven't been able to attend the previous panels. I was teaching until just a few moments ago, so I could just pick up on the last part of the discussion, but I haven't been able to attend the whole seminar. In 20 or 25 minutes, I will try and explain the report, and I'll try to share with you what we have been trying to do from the observatory. As explained by Esperanza, the observatory was created around March 2022, and thanks to the support of Plena Inclusión España, LIBER, and in collaboration with the Institute of Human Rights Gregorios Pérez Barba of the University Carlos III of Madrid, this has been advancing his work, and that the former is where I conduct my research activities from. The observatory was created under the belief that the reform proposed by the Law 821 could result in a fundamental change for people with disabilities, so that they could lead a decent human life, they could enjoy their fundamental rights, and also from the conviction that it was needed to have such a law. It was a law that tackles no more and no less than an issue of legal capacity, an issue which is transcendent for law and for rights too, and indeed for the very idea of human rights. One of the great references is indeed here the idea of human dignity. We've often said this. The idea of human dignity was, in a way, something that was built on the narrative about rights without really factoring in disability. And it was necessary to remember that it's not necessary to link dignity and capacity, and that people with disabilities indeed have the same dignity as any other individual. We see this in the Convention of the Human Rights of People with Disabilities in Article 12, and actually the Committee on the Rights of People with Disability also had told Spain in several occasions that there was a need to change the regulation, and that it was necessary to create a regulation that had as a central pillar the respect for rights and preferences of individuals. And this is why this law is especially relevant. And legal experts know this very well. Laws
son una herramienta necesaria en muchos casos,
are a necessary tool in many occasions, but they're not enough to result in changes. Laws are texts that need to be interpreted, and legal experts know about the importance of the interpretation and implementation of laws. And because of this, it's very important to keep an eye on how the legal community interpreted that reform and how that reform is being implemented. And therefore, the reform will not just be implemented by judges, the reform is implemented by the legal community as a whole, and actually legal operators, and this could include citizens, with the use that we do of this reform from a very specific perspective too, because this creates a legal culture, and it also emphasizes the role of judges. And this is where the role of the observatory stems from. It needs to focus on making sure that the content of the law is implemented in accordance with the convention and legal provisions on human rights, also establishing KPIs that allow for the analysis of jurisprudence, proposing also methodological and regulatory changes aiming at having people with disability equally recognized before the law, and finally also identify training needs amongst legal operators. So this is one of the roles of the observatory, and in order to serve this purpose, team has been put together. It's made up by 20 researchers, and Esperanza is a member of this team too. This includes university professors and also some law practitioners outside of the scope of the university or outside of the university. What we did was to create a work methodology, starting from a document template in which we include the type of decision, the speaker, the transient provision that it's being alluded to, who is leading the procedure, whether the will of the person with disabilities is being respected, whether there's procedural adjustments, or the background, if sentences are quoted, which are the sentences quoted, the stance of the prosecutor, whether there's training needs, and we also ask researchers to come up with an initial assessment of the resolutions, and if necessary, for them to identify some that are considered excellent. Now, the observatory was created in March, and in April we started working on the first resolutions. What I'm going to try and share here today are the first 14 months of that observatory. Actually, the period that runs through to last summer, 2023. About 351 resolutions have been analyzed in that time. Currently, the observatory continues to work, and we have an analysis underway, including 100 extra resolutions, and I think that they will be ready by the end of December. So therefore, we will be reaching about 500 resolutions. And depending on how you look at it, for some this may be too little, for some this could be a lot, but for us this is indeed a significant sample, because the observatory is trying to analyze resolutions of all autonomous regions and the Supreme Court, first instance courts, resolutions that we are getting thanks to collaborations that we have with institutions or with professionals, with a legal counsel that provide this for us, and also considering the available databases. We have sometimes a hard time trying to get a hold of these resolutions. Some of them are courts of first instance, and these resolutions are not available in databases. So we really need to resort to the collaboration of people who are collaborating with Plena, inclusión, LIBER, and other professionals. So let me say that, well, after having set the backdrop and set the scene for the observatory, I'd like to share some data with you. I think that they're very relevant, and they stem from the analysis of the resolutions that I just mentioned. Part of what I've seen, the on the resolutions that, and I'd also share what I'm seeing in the assessments that are underwent, and I will talk about quantitative rather than qualitative, qualitative rather than quantitative analysis. 172 of these resolutions come from courts of first instance, and out of those courts of first instance, there's 105 positions and sentences. 176 resolutions from provisional non-distance have been analyzed, and 20 of those resolutions are rulings, and 146 are sentences. And then we also have 79 of the Supreme Court. 15 of the High Court, and out of all these resolutions, 32.5%, 114 rather, come from voluntary proceedings, and 217, 67%, are claims or disputes. And indeed, it's not surprising that there's more that have to do with disputes, because indeed there's been processes that have adapted, and they were initiated in the context of this new situation. But there's a change in trend, and the two proceedings are becoming on par.
An important thing of the analysis is to see the involvement of the person with disabilities in the procedure is something compulsory in the regulations. We know that 40.7% of the cases we see their involvement, but in 59.3% we aren't sure. And we have questions and doubts. And there, what's clear is that of all those, resolutions or decisions, which are 67% of the resolutions examined, we draw the conclusion that there's no involvement whatsoever. Maybe sometimes the judge don't inform about their involvement in the procedure, but almost everything leads us to think that the person with a disability is not involved in most cases. About the person with a disability, this is one of the guiding thread of the reform. Around 22% of the court rulings, the investigators that analyze them, we see that we don't respect the will of that person in 22% of the cases. Just in 2% of the rulings examined, we see that there have been adjustments in the procedure. Also, interesting to see is that 61% of the rulings examined, so a good amount of the expert report is carried out by forensic doctors, not taking into account other kind of experts or other kind of reports of experts reports. And also a significant aspect that is surprising is the review term for the decisions adopted or the rulings. The reform sets in the Civil Code in 268 code that the review period should be below 3 years, the term, and exceptionally reaching up to 6 years, provided that this is there is a motive for the exception. Well, only in 32% of the rulings there's a delay or a term that is below or the same as 3 years, and 20% is between 3 and 6 years, and in the rest of cases we don't see any review term established. Also important to see that practically in 40% of the rulings we quote a ruling of the Supreme Court, 589 of 8 September, the first sentence of the Supreme Court on the reform, setting a line that I will mention briefly later, but that is present in almost 40% of the rulings. So the Convention on the Rights of the People with Disabilities is present in 60%. So we quote 61% of the rulings examined. And as I was saying in that request made to the investigators on the assessment of the rulings, for the investigators of the observatory, of the rulings examined, 34.5% present problems for our investigators. If we adopt a human right approach, taking as a reference the convention, so around 34% of the resolutions, we believe present problems if we take into account what the Convention of the UN for the people with disabilities set. And only 9.11% of the rulings are considered to be in sync and completely synchronized, or that are fully adopting the approach of the Convention for Human Rights. Also is the opinion of the investigators of the observatory that 69% of the rulings examined, we can see that there's a need for a further training or the adoption of an approach with a human rights approach. About, well, not so much numbers, but qualitative matters I wanted to to give you some thoughts. I wanted to do give you three main insights. Now, the importance of the Supreme Court text that I think is relevant in analyzing how the law is being applied. Then I will emphasize good practices that we've been able to detect, and also bad practices too. Although these data, some of them maybe have been amended or corrected. And this analysis carried out, there's a sentence 589/21, 2021, because it was the first sentence, the first ruling, sorry, that took as a reference the reform. This ruling 589/2021 of 18 September, but I'd like to name other rulings that I think may be relevant. 589/2021 is very important because it's not that it set a case law line, but that it has been followed by many other courts. And in this ruling, it lives without effect the amendment of incapacity, replacing a tutelage by a curatorship. And it sets a series of measures, support measures, that are important for the person with a disability. In this case, it was a person with a disability they accumulated many things at home, and they presented setting their ability and the support they needed with a Diogenes syndrome, declaring a mentor with some support measures. And this, there was appeal in another court in Asturias, and the appeal was rejected with the conclusion that they had a relevant, the subject had relevant disability, sorry, and they said that that person wasn't aware of the severe disorder they had, of the personality disorder, and the ruling was appealed before the Supreme Court, and the Supreme Court places the tutelage or guardianship for the curatorship. And I'm not talking on behalf of the observatory, but on behalf of an investigator of the observatory. But the most relevant thing of this ruling is how the court understands this 268/21 with where they say that the measures will be provided depending on the needs of the person, and that always respect the autonomy of that person and the excess of their capacity. And it says they will take into account their will, desires, and preferences. Well, what the Supreme Court is saying is that this, what they say, this claim of the 268, say that the measures will in any case take into account their will, desires, and preferences. Well, taking into account or attending to doesn't mean satisfy or meet. Now it's for the court to decide if we have, to take into account their will depending on each case. And what they say in this case is that the contrary will is the fruit of the lack of awareness because of the disorder. That's why we justify adopting attendance or assistance measure against the will of the subject person, because that person doesn't have a clear awareness of their own situation. Here, the court has some considerations that help understanding, but that brings us far from the convention, and they state that not intervening in these cases under the excuse of respecting the will against the person will be social cruelty. To abandon the person, so it will be social cruelty to abandon the person who, because of the direct effect of a mental disorder, is not aware of the personal degradation process they're going through, they suffer. And they say, well, the provision of support in these cases entails the assessment that is this person didn't have this disorder. They would agree on avoiding this personal degradation. So this ruling, as I'm saying, or maybe another point of the ruling, the doctrine said takes the reference the conditions, but not here, not in this paragraph. I'm going to speed up, but I'd like to quote two rulings from the Supreme Court that are important or interesting from 2023, this year. So 1291/2023 for the 23rd January, and 1444 of the 20th of October. And these are two rulings from the Supreme Court where the magistrate herself was a speaker. So I encourage you to read this because they mention the scope and the safekeeping of a disabled person. And in both of them, we took into account that the code prioritizes the voluntary measures, and also that the code prioritizes the informal measures over the legal ones. But the first one, we consider that the right instrument is the facto guardian, which is the son or daughter. And in the second one, the magistrate believes that the measure is the representative curatorship and not the de facto guardian, because we believe that de facto guardian is, in this case, insufficient. So I don't have time enough to, but I encourage you to read this. I don't have time to explain the ruling, but I encourage you to read these two rulings because there are two. Well, we argue about the de facto guardian, and the magistrate considers on the one hand because of the circumstances of each case and a series of arguments that, well, yes, we have to keep the de facto guardian, but in the other case, they take into account the representative curatorship as an extraordinary measure. So good practices. Well, we have seen some good practices, but it's true that when you analyze good practices, sometimes you say, well, the good practices, or what we call good practices, is just law compliance, law enforcement, and in our report, we quote some rulings as good practices, but these rulings just respect the will of the person with a disability, and it shouldn't be any different. Or the prevalence of voluntary measures and informal measures over the rest of the measures. Well, of course, this is what the reform says. Or the right limitation of the support when adopting measures. I mean, this is what the reform was asking for. But we did find some bad practices. Well, some of them are not very relevant because they took place at the beginning, in the first months of the reform. And there we found, some things that, well, are surprising, no? Some rulings where they didn't even know about the reform, and then they just set the guardianship of the person, and something that was out of the question already, and depriving them of the right or incapacitation. No, I think the first one of law 8/2021, where they stated that depriving of right is something that is eliminated with the reform. Also, we found rulings against the will of the person with a disability. Some of them, well, based on the doctrine of the ruling of the Supreme Court, where they pointed out that, well, taking care of the will doesn't mean meeting or, following their will. So the ones that take into account the go for curatorship and not setting a review term, it's compulsory to set a review term. And some of them, we have a ruling that sets a term above 6 years, which is something we cannot do, a review term. And some of them do so, but without any motive. And they say this will be reviewed in 6 years without any specific motive, no motive for setting that term. We also, and I was saying this when take a look at the data, rulings that, well, that don't take into account the will of the person with a disability, because they are not part of it, because it looks like they were not involved in the procedure. And in this case, these cases, the judge just approved the experts' reports, or what came up in other, well, legal courts, and they just took that as enough. Also bad practice, using specialists that go beyond forensic doctors. The large majority of experts' report are provided by forensic doctors, as we said, and also the most significant, maybe the worst practice we saw is in some cases some kind of automation. No, in some cases, so by some judges of turning, well, the guardianship into representative curatorship. So Article of the Civil Code 249 of the Civil Code states, especially that just in exceptional cases, when in spite of making a considerable effort, it's not possible to determine the will, desires, and preferences of the person, the supporting measures may include representative functions. We have found certain automation and saying what was the guardianship. I'm going to turn this or change into representative curatorship with broad faculties to support in the health, financial and personal sphere, overlooking this reform. And just a couple of minutes more. The first conclusions after these months in the observatory, amongst our goals was to set indicators. We have a first proposal for indicators that we're going to, to show after analyzing the case law. Also in the human rights sphere, we have standardized some behaviors. Also, if we make a general assessment on how the law is being applied, this cannot be a positive assessment. Our approach is for human rights, a human rights approach, and very few times it makes you give a positive view of the reality, and this is something we must say, and we have to take into account that the field we're analyzing is the adaptation of processes that started in the new field, review, and this has nothing to do with the reform, because the big reform takes us to, de-judicialized things. So this takes us to a specific field, but we do believe that this law requires new gaze for the legal capacity. And even if many efforts have been carried out, the legal community, and in this case, judges in many cases, haven't carried out the cultural change that the reform enables. No, it's not a problem of the judges, it's the legal community. And the need for a human rights approach and a change in understanding that all human beings need support, and why it's important to be aware of the role that the will plays in our decisions, how we're all conditioned by, not just people with disabilities, and the human rights approach that entails, to recognizing that everyone has the right for the free development of the personality. They have the right to decide how they want to live their lives. They're respecting the will of the people is something that is essential. So all this cultural change takes time, and this way I want to give a positive note. So we can feel there's a change going on in the rulings and in the new rulings.
Not in all of them, perhaps, but there is indeed a change, and we're seeing that these resolutions are adapting more to the resolution and to the human rights approach. And I apologize, Esperanza, because maybe I consumed too much time, but these were some broad brushstrokes on the assessment that we've done on the resolutions. Rafa, it is indeed very interesting, and you summarized it very well. And at the same time, you have also shared a masterclass on how the law should be applied, implemented, and what this means. There are no questions, but no, Esperanza, I actually do have a couple of questions.
si creo que no lo has dicho, Rafa, pero no
I
sé
don't
si
think you mentioned it, Rafa. Perhaps there aren't any. Are there any cases in which there are rulings that ratify the voluntary support measures that have gotten to a revision period or level? And maybe Esperanza can help us here. Are there cases in which a revision deadline is not fixed, and when it's when they don't take into account the will and preferences, or if there is no assessment on the needs to adjust the procedure, couldn't this all have an impact on the mandatory contents of the ruling? I think that in Law 8, in the convention, there is an innovation about the contents of the ruling, and also in the face of strategic litigations. The question would be, what are the possibilities to argue that a ruling doesn't contain all the necessary and mandatory elements? If it doesn't contain the revision period or the will and preferences, if there's no references to them, if this is not if the ruling does not assess whether there's has been included. I don't know if I made myself clear. Well, about the first point, if I actually understood what you meant, Ines, you wanted to ask whether we have received at the observatory the revision of measures, not tutorship. If there is indeed a revision, if there is a revision, but the document subject to this revision has a document with voluntary measures establishing the preferences or the will of the individual, judges consider that this is valid. In the first rulings, I don't think we've had any of those cases. I don't know about the ones that are currently being reviewed. Right now, we are evaluating quite an important volume, and I don't know if I failed to mention this, but the observatory is actually collaborating with a legal clinic, which is another way to go about training and research and through service learning too, for future legal experts too, because it's very important for them to grasp this new culture brought about by this law. And many of these are being evaluated in the clinic, and perhaps some of them will fit what you said, but I know of none so far. And the other comment, well, maybe Esperanza could respond to it. I work in law philosophy, so I'm like up there thinking about things, but the first thing that this prompts in me is human rights. One may think that Article 24 of the Constitution, which is effective judiciary tutorship, that is touched on. Some of the guarantees are lacking there, and this is the first thing that this comes to mind. But Esperanza, you're more acquainted with this. Well, you could go through appeals if there is a ruling that is not really portraying the adequate measures. If the law is not being complied with, then you can take it through the path of appeals and repeals. It's not ideal because you know how long this takes, and we are actually making difficult the life of many people, and this is actually something that is indeed happening. And there are rulings about this, and I think there's no other solution to this. When judges or justices are non-compliant and are failing to implement the law, to comply the law, I wish there was another solution, but I cannot see it right now. And actually, Rafael earlier on was referring to some malpractice cases. There's also good practices, but I found striking a ruling in which they made a reference to a convention, to the law 821, and the text of the ruling was about tutorship, etc. So the content had been pre-drafted. It was about tutorship, even though in the beginning it said conventional law. I mean, that goes to show a lack of interest and professionalism at the end of the day by some judge or justice. Rafa, participants have said that it's good to hear us, and it's important that judges also interact with legal experts too. This is something that is included in the law too. They were also challenging that this is a convention that is not being complied with in practice. So that gives us a glimpse of hope, right? It's true that different analysis of the application of jurisprudence are being made, and some analyses are more optimistic than the one that I shared here. But I said it from the very outset. I think it's very important to have a rights-based approach, and it's a demanding one. And if you actually want to think about change here, and this change will be a demanding one for that matter. So the issue of legal capacity and the very issue of disability, in a way, are very present, but need to be changed. And the way to change this is by raising it, and that is very important. And it's true that there's good resolutions. It's true that we see that there's improvements and there's better human rights-based approaches, but actually there is something that we are detecting at the observatory, and it's something that we're doing that has been done, and more could be done too, quite possibly. So the human rights approach ultimately should be something that judges take more into account. The convention is an international instrument. We have Article 10.2 in our constitution that obliges us to take it into account. This is a human rights related issue, so we must approach it like what it is. So I think it's very important too. Thank you. I think we can actually conclude this last section. In a couple of minutes, I am going to share some closing remarks. I'm Inés Zaraoz, and I coordinate the legal department of Plena Inclusión, Spain. Firstly, I'd like to thank all the people who have participated in this. And every time we call on them, they respond, they offer their collaboration, and we can always count on them. As you can see, we have a strategic objective in Plena Inclusión, which is to advance towards inclusive justice, justice for people with disabilities, and obviously chiefly for people with intellectual disabilities and developmental disabilities. And we have been trying to organize activities to tackle the situation of helplessness that sometimes is suffered by people with disabilities when they have to embark in a legal procedure. And this translates into many different aspects. In some cases, this has to be approached through lobbying or through campaigning or investigation, legal innovation, training too. And there had been work on procedural adjustment and work on the figure of the intermediator or the intermediary rather. And we've seen how there's tools, for instance, augmentative communication tools that we can use in legal procedures. And in a way, what we try to do here is for legal operators to be acquainted with this when they see that a person is using alternative and augmentative communication tools, for them to not be left aside because of this. Also, we've talked about easy reading documents, because even if people can have access to notary offices, if the necessary means are not in place, they will finally not make use of them in reality. And this is something that has been discussed during the panel. And there's also needs in research. We've been discussing in the last panel that if we don't gather data if we don't analyze those data, we will not be able to do advocacy or to propose actions that are well-founded and that are efficient. We need to base our work on evidence. And finally, the ultimate goal of the work that we do is to disseminate our knowledge so that we don't just keep it to ourselves. We want this to be made available for organizations, for individuals, for families, for people with disabilities so that they can all make use of it. And always we want to strive for collaboration. Doing things on our own is not that useful, and this is why we always collaborate with the APF, the Association for Forensic Medicine, AICTAS, University Carlos III, and in other occasions we also interact with health experts such as Al-Fasad and other institutions that represent legal operators, the prosecution, the General Council of the Judiciary, the Home Office. So we want to have everyone reinforce these ideas. We know that we have to disseminate knowledge on how we can enhance access to justice for all individuals, and we need to do this jointly at the end of the day, because when things come to fruition, they normally succeed because we co-participate, we co-create with all the different stakeholders and those people who, in a way, are victims of the system. So thank you very much to all individuals who have joined us. And I'd like to especially thank my colleague Azara Bustos and Natalia Perez from the legal department. They have been in charge of organizing this seminar. There's other colleagues who have helped us with communication, with the media, with interpretation and translation. And the seminar has been recorded because it's relatively long. We will try to divide it into different sections, and we will make it available to you on our website. And we will also try to disseminate it as much as we possibly can through our social media. Thank you very much. We normally hold one per year, so I'm hoping that we will see you on the next one. Thank you very much, everyone, for joining.